The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
I'm Judge Valerie Zachary. Serving with me on this panel are Judge Toby Hampson and Judge Darren Jackson. Assisting us today are Attorney Jean Soar with the Office of the Clerk of the Court of Appeals and Ziad Hawk with the Supreme Court IT Department. We are live streaming this session of the Court of Appeals as we conduct this oral argument on WebEx. We're happy to welcome everyone to our virtual courtroom in the spirit of our tradition of publicly held proceedings. We have one case on the calendar this morning before this panel, State versus Justin Stephen Herr. If counsel are ready, let's proceed. Appellant will argue first. Ms. Muma.
Good morning, Your Honors, and may it please the court. My name is Christine Muma with the North Carolina Center on Actual Innocence, and I represent the defendant, Justin Herr. I would like to reserve 10 minutes for rebuttal. In this case, there's a stated question of where the evidence showed that the defense attorney's deficient performance prejudiced Mr. Herr's decision to plead guilty in 2012. Did the court err in denying his ineffective assistance of counsel? The court is very familiar with the two-pronged process of Strickland with regard to determining ineffective assistance of counsel. In this case, the trial judge determined that regardless of the performance, the defendant's decision to plead guilty would not have been impacted. So relying on Hill, the court found because there was no prejudicial impact, he did not reach findings of fact with regard to performance. I would argue that in this case, it's particularly important to note the performance because the defense attorney actually testified on the stand that his practice, not just in this case, but in all cases, is to not investigate or conduct any interviews whatsoever if there is a chance the state is going to offer a plea or the defendant will accept the plea. And as far as counsel's performance, we would argue that that is per se ineffective assistance of counsel. But with regardless of whether that is the case or not, I think the facts in this case will clearly show not only was the decision of the defendant conditioned on reliance on his defense attorney, and so he was in fact prejudiced by the lack of steps the attorney took, but also that there were many factors, many steps that could have been taken that would have resulted in this defendant insisting on going to trial. The court found that because, let me just give a little bit of background on the facts. This was a plea hearing, and during that plea hearing, the facts were laid out regarding 3 incidents. The first incident being a situation where the daughter, Casey, described the defendant as pushing her down on the bed and telling her to spread her legs, and then she kicked him and he left the room. The second incident being the defendant entering the room of Casey when there were 3 other teenagers in the room, and the light bulbs had been unscrewed in the lamps and it was dark, and the defendant groped around and touched Casey's thigh, and she described it as rubbing her thigh. The third incident that was alleged was Casey had a rash on her back and front. She was advised by her parents to take a shower, and the defendant went in after she showered, and her original allegation was that he lifted her shirt in the front and fondled her breasts, and then told her to turn around and pulled her pants down from behind. That clearly was the most serious allegation and was the allegation that set everything in motion in this case. That allegation was also completely recanted. It was recanted in a forensic interview, and the trial court found that even though it may have been the defense attorney did not inform the defendant that there was a recantation, and the trial court found that it may have been true that he did not show the video of the recantation to the defendant, because the incident was unrelated to the two incidents that he was pleading guilty to, it was irrelevant. Our position is that those allegations were all intrinsically connected. But for the third allegation, there would never have been charges, because the first two charges were the defendant in the first case said that he, when that incident happened, there was a tick on his daughter's thigh, and he told her to stay still and to keep her thighs spread so he could get the tick. There was a witness to that event. Another daughter was in the room. With regard to the second allegation, there were three other teenagers in the room. So there were four people in the room, four teenagers in a dark room, where this parent, in fulfilling his parental duties, went into the room to find out what was going on. When he tried to turn on the lights and realized the lights were not coming on, he groped through the room to find someone and ask what was going on. That's when he found out the light bulbs were unscrewed.
Can I jump in with a question here? So, one of the things we have to deal with as an appellate court is the trial court's order itself, and particularly with the standard of review. Is there evidence to support findings? And do the findings support the conclusion? But here, one of the things we're dealing with is that while the trial court kind of walked up to the line as far as performance, and indeed whether defense counsel informed defendant of the recantation itself, the trial court never actually made findings, right? Those ultimate findings on which the conclusions might hinge here. So, is there a need, if we were to get past the prejudice conclusion, would there be a need to simply remand this case to the trial court for further findings of fact on those kind of ultimate factual issues?
Yes, Your Honor. The findings, the remand is absolutely a possibility. There are many findings that were not addressed, but I would also say that the trial court did make two findings in reaching his conclusion that there was not prejudice. One was that the incident that was recanted was unrelated to the other two incidents he was pleading guilty to. So that was something the court found as to justify his finding of lack of prejudice. The other thing he found was that the further investigation would not have revealed any information that would have changed the defendant's decision about pleading guilty. And the thing about that is the defense attorney himself testified that he did not investigate, that he did not interview anybody, and that was not his practice. And the court did find that based on the attorney's own testimony, there was only 12 hours outside of court used to investigate, to review this case, to enter into plea negotiations. The court found that the attorney admitted that he did not conduct any investigation. The record shows he filed one motion for continuance and one motion for discovery and nothing else. And also, very importantly, he did not object during the plea hearing when the incident of the recanted incident was used as justification for the plea. There were 2 lines that the prosecution used to describe the first incident, 2 lines for the second incident, and 5 lines for the third incident that should never have been brought forward. The defense attorney never objected to those facts being presented. Those facts were the only facts that included any element of indecent liberties. So the court did find that there would not have been anything additionally uncovered had he looked at the deficient performance element of it. So because he mentions those 2 things, the Court of Appeals does have the ability to include those as findings of fact that the court made and find that they were in error. So I do think there's a possibility to considering those findings of fact to vacate, but there's also the possibility of remand for additional findings of fact. But I think there's evidence to support either way. Does that answer your question, Your Honor?
It does, and you know, and that sort of leads, I think, into the next part of the argument, which is, you know, what evidence is there of prejudice other than sort of the mere allegation from the defendant that but for the deficient performance he would not have pled guilty?
Well, the court did rely on the holding in Hill to reach just the prejudice prong. And this case is very different in Hill because in Hill, the defendant did not allege that had he known of the new evidence, he would have insisted on going to trial. In this case, both the defendant and his wife gave testimony that had they known of all the details in the case, they would have insisted on going to trial. So it's different than Hill in that they both testified that not knowing about the recantation, not knowing or being able to investigate the threats that were made against them. This man was not only had this child, but had 3 other younger children. And so the consequence here was he was losing the right to be with all 4 of his children, which was a significant loss. So measuring that loss with the other evidence that would have come forward had the defense attorney investigated is a critical element of the analysis in this case. Had the defense and the defendant did not find out about the plea until that day, that hearing. That was only the second time he met with his attorney. So he was faced with this decision without knowing, 1, about the recantation, or 2, about what level of investigation the attorney had done that would make him give this advice to the defendant. So although it's claimed that the defendant made a took a knowing and voluntary plea, how could he have a knowing plea when he didn't know what the attorney knew? And had the investigation been done, the attorney would have found, 1, this was an unhappy 15-year-old child who had her freedoms restricted, and as many 15-year-olds was rebelling against that. She was unhappy with her parents' financial situation. She had an aunt who had more money and gave the child more freedom and provided more things. There was a squabble in the family over who would have access to property after a parent was deceased. It was an unhappy marriage. The trip to Pennsylvania was positioned as this taking the children out of state to get away from the husband, rather than what it really was, which was an annual trip that they took. It would have been revealed that the child did not contact the police with these allegations. The aunt did, that the defendant's sister contacted the police chief, who was a friend of hers. When the child did contact the police chief and said, listen, this third event, I was told to exaggerate the facts. It never happened. The police chief called the aunt and said, what do we want to do about this? So there were a lot there was a lot of evidence that could have been presented to a jury that would have explained how all of this came about and most importantly, would have shown that the two incidents that were left after the complete recantation did not meet the elements of indecent liberties. There was no act that was done for sexual purposes of sexual arousal. So the basis, even the judge during the hearing, when most of the time was spent giving facts that supported an allegation that had been recanted, said, well, the recantation is an issue for the jury. And the defense attorney actually said to the judge, well, you can see, Your Honor, why the facts of this case would justify this plea, instead of saying, Your Honor, that the two incidents they're trying to get him to plead to do not meet the elements of indecent liberties, and there's no evidence to support the third.
And that actually leads to a sort of a third question I have, which is in the motion and supplemented motion for appropriate relief. My recollection is that the relief requested is that the convictions be vacated and the charges dismissed. Why wouldn't the appropriate relief here, given that this was a plea agreement, and why wouldn't appropriate relief here be simply to vacate and remand for new trial, given that what you're trying to do here is set aside a plea agreement, in light of cases like RICO and other State v. RICO, where we've held that the remedy for setting aside a plea agreement is not just to do away with the plea agreement to the benefit of just the defendant or just the state for that matter, but the remedy is to put the parties back in the same position they were prior to the plea agreement, which is go to trial.
I understand, Your Honor, and I think the motion did say, or whatever relief the court finds to be appropriate. So yes, in our minds, for the sake of efficiency and effectiveness of the justice system, when you have two charges that do not meet the elements of the crime, there's no reason to remand for a retrial, but to vacate, because there's no basis for the charges. But as we stated in the motion, there was the other alternative for the court to remand for retrial. So the prejudice, we believe, is clear. The trial court was incorrect to say that the recanted act did not have any correlation to the plea. The plea was based on that act being described. It was relied on by the prosecution for the most of their recitation of the facts. It was not objected to by the defense. So we believe the trial court was wrong in finding they were unrelated. We also believe the trial court was wrong in saying that had the attorney conducted a complete investigation, he would not have uncovered any facts that would have caused the defendant to insist on going to trial.
Excuse me, just to make this clear, the ADA mentioned the recantation before the plea was entered into?
That's correct.
Okay, just want to make, thank you. I wanted to.
That's correct.
I wanted to make sure I understood that. Okay.
The details of that act, the rubbing of the breasts and the pulling down of the pants, those were the only actions that were ever alleged to have be associated with sexual arousal, and those were completely recanted, but they were used as justification for the plea.
Okay. Thank you.
With regard, so we believe if the judge had gotten past the prejudice prong and looked at the deficient conduct, performance, the courts have held the strategic decisions of counsel are to be respected if there's some basis for that strategic decision. In this case, there was no basis for the strategic decision. There was no basis to not conduct additional investigation. There was just a stated practice on page 227 of the MAR hearing. You'll see that the attorney actually says, my practice is that I don't investigate, I don't interview unless I know there's not going to be a plea offer, the defendant's not going to take it. That is not providing effective assistance to counsel under the ABA or under the professional rules of conduct or under the standards of the court in a way that provides us with an opportunity to have confidence in the outcomes that we receive in our justice system.
Oh, excuse me. Well, if the defendant knew about the recantation before he entered into the plea agreement, couldn't he have, stated at that point, wait, judge, I did, yeah, I did agree to this, but now they're saying this and I didn't know about that.
Well, the defendant did not know about the recantation beforehand, which is part of our issue, is that the defense attorney did not keep his client informed, which is a violation of the rules. So the defendant did not know about the recantation. He had met with his counsel prior to the hearing, and counsel actually told him that if he did not plead guilty, the children were going to be taken from the wife. That they were going to lose custody of all 4 children were going to be put into foster care. So he went into this hearing with this fear that was put into him by his defense attorney about what he was advised. And when you're in a plea hearing and you've been told what to say, and this pops up, your ability to respond is very limited. You are relying on that counsel, and that counsel for Mr. Herr completely failed him in not being his counsel. Whether it was because he was formerly a prosecutor and then went back soon after this to become a prosecutor again, I don't know. But I do know that he did not provide Mr. Herr with counsel during that plea hearing, and Mr. Herr was misled with regard to what the evidence was.
I just to clarify the facts here and the facts of the plea hearing itself. The assistant district attorney did not mention the recantation during the hearing, correct?
She did. She did.
But
this
the
is what
allegation
the judge said, because she said, let's see, I'm sorry, because that's what caused the judge to say recantation is definitely a jury issue.
That's right. And I know I'm cutting into your rebuttal time here, so.
That's okay, but yes,
you're right.
It was mentioned, and so, but it was skipped over very quickly, and then the defense attorney said, you get a clear picture of why this plea is appropriate. I will reserve the rest of my time for rebuttal. Thank you, Your Honors.
Thank you. Judge Hampson, Judge Jackson, do either of you have further questions?
No, Judge.
Ms. Lawrence, you may proceed.
Thank you, Your Honor. May it please the court, I am Sherry Lawrence, Special Deputy Attorney General with the North Carolina Department of Justice, and I represent the state in this case. The trial court properly denied the defendant's motion for appropriate relief without addressing the deficient performance prong of Strickland, and determining that the defendant did not establish prejudice such that there is a reasonable probability that absent his attorney's alleged errors, the defendant would have not pled guilty and went to trial. In this case, Strickland versus Washington applies. This is not a per se ineffective assistance of counsel issue, which I think I heard counsel, and maybe she misspoke, that this was per se ineffective assistance of counsel, which would fall under other case law. However, Strickland applies in this case, so this is not a per se case. The trial court in this case only addressed the prejudice prong. So to address, also to answer Judge Hampson's question, your question about whether or not the proper remedy would be to remand for the trial court to make findings on the deficient performance prong. If this court determined that the trial court was wrong as to prejudice, then that would definitely be the correct course of action. However, in this case, the defendant failed to establish prejudice. The July 2011 allegations were the only allegations that this victim recanted. The prosecutor during the during the plea hearing, 2 times the prosecutor referred to the recantations. And if you look at the plea hearing transcript, the prosecutor stated, and of course she used her actual name, but she stated Casey was unhappy when she left the state and recanted the allegations, saying it wasn't true because she wanted to come back to where she had lived. The prosecutor also stated during that same plea hearing transcript hearing, I'm recanting because I just didn't want to have to live in another state away from all my friends and family. These 2 statements were made during the plea hearing. They were made during the state's factual basis for the plea, which was prior to the trial court formal acceptance of the plea. It would have occurred after the trial court, according to the transcript and the process and procedure for the Superior Court. It would have occurred after the trial court went through the entire plea with the defendant. In this case, what's interesting is if you look at the transcript of plea, the defendant, this is not an Alford plea. The defendant stated that he was pleading guilty, and he was pleading guilty to those offenses listed in the transcript of plea as well as in the transcript of the plea hearing. In addition, the defendant is not contending that his plea wasn't knowingly, voluntarily, or intelligently given, and that it wasn't a willing plea, which I guess would sound like that's kind of what he's trying to say, but he's not contesting that at all, which I think is
But isn't that exactly what he's contesting by saying I could not have made a knowing, intelligent, voluntary plea without having my attorney provide me all the information I needed, or at least, you know, a reasonable amount of information that I needed to enter a knowing, voluntary, intelligent plea. You know, given the fact that the lawyer really had conducted no investigation, had not informed him of the recantation, had, you know, at least even the trial court found counsel's performance was at least troubling here. That isn't that in effect exactly what the defendant's contesting, and maybe the real question here is how would a defendant in this situation actually prove the prejudice prong, short of testifying, I would not have taken this plea had I known the lack of investigation, the recantation, etc. I mean, what does the defendant do to prove the prejudice prong here?
In this case, for the facts of this particular case, I think it's clear because he was provided with that knowledge. His trial counsel testified at the evidentiary hearing that he did go over the case file with him, and that's at page 210 of transcript volume 1. In addition, those 2 statements made by the prosecutor clearly put the defendant on notice. And I think that it definitely corroborates trial counsel's testimony at the evidentiary hearing. So for purposes of this case, that definitely establishes that the defendant had that knowledge prior to entering that plea. And I think that's why the issue is not framed in that manner, because that knowledge was out there, and it was out there prior to the plea being entered. So for purposes of this case, and applying Strickland versus Washington, the defendant would have to point to something in addition to, I guess what they're saying here does not rise to the level of prejudice, because he was aware of the recantation. He's saying he would have changed his mind had he known about the recantation. However, he was aware of that recantation. And even with that knowledge, he still entered a plea that he's attested to being knowing, voluntarily, and intelligently given.
Well, would you agree at least that the issue of whether the defendant was aware of the recantation prior to the plea hearing is a disputed issue of fact?
From the defendant's point of view, yes, because the defendant is now claiming that he was not aware of that. However, I think it's important, in the trial court conducted an evidentiary hearing. The trial court heard evidence as to, I guess, what all happened, and the trial court didn't make a finding of fact specifically stating that he was not aware of that recantation. But I think the record evidence supports the fact that he was aware of that recantation prior to entering that plea. To decide otherwise, we would have to disregard the prosecutor's statement as well as the testimony that the attorney was given. So yes, it is a disputed issue of fact. However, the prosecutor's statement clearly corroborates the attorney's testimony at the evidentiary hearing. There were two.
Didn't the attorney also, the defense counsel also testify that he could not remember one way or the other whether he provided any of the file materials to the defendant or shared the discovery materials with the defendant, and that too, now those files have been destroyed anyway?
He did, and there was some, I guess, hesitation for him to say for sure as to whether or not what exactly he did in terms of that file. However, at page 210, he specifically answered that he discussed the forensic interview, which contained her statements in full and her recantations, and the case with the defendant. And that's in volume 1 at page 210. He specifically stated that he had discussed those things with the defendant. In addition, just going back to the prosecutor's statement on the record, I think at that point, that would have been the defendant's chance to say, hey, what do you mean recantation? I'm not accepting this plea because I wasn't aware of this at all. So from 2012 into 2018, the defendant had been back and forth in court multiple times during this time period. So I think the record evidence outside of just Attorney Kinney's statements at the evidentiary hearing, outside of that, we have concrete evidence in the transcript where the prosecutor stated twice and talked about these recantations. In addition, the prosecutor stated during the evidentiary hearing that she had discussed these matters with the attorney, including recantations. And at this plea hearing, she makes these statements, specific statements about these recantations. So we would contend that corroborates the fact that corroborates the attorney's testimony, that he did inform him about those recantations. So the defendant was aware of these recantations, and the record evidence does show that. Even, I guess at this point, even in this particular instance, looking at that guilty plea, going back to that, the things that he swore after hearing that, prior to hearing the factual basis, and then even after, not ever contending there's an issue, there's something I don't understand, they brought up this recantation, I don't know anything about that. And that occurred because he was aware of it. And the prosecutor stated on the record, Attorney Kinney testified as to it at the evidentiary hearing in addition to those.
Well, but isn't that exactly what we would expect defense counsel to raise the objection to? And I know these arguments put you in sort of a tough spot, arguing what defense counsel should have done in that, but isn't that exactly what we would expect the defendant's lawyer to object to and to raise as an issue, rather than relying on the defendant themselves? I mean,
well, I think if I understand Your Honor's question correctly, I think that goes to the gist of the argument. He's saying that he didn't know, but counsel knew. So if counsel knew, then counsel would not have objected to that portion of it, because as to the DA's two prosecutorial statements about the recantations, if the defendant did not know about those recantations and hearing that at that juncture, the defendant should have objected, because now he's contending he did not know, but his counsel knew. So I think defendant's argument regarding the objections during the plea hearing, it goes to the mention of the July 2011 incidents during that factual basis, and that he should have objected to that, which I would say that's of no consequence. That's of no consequence here, because he pled guilty to the two offenses that she did not recant on.
But how did it not play? How is it not relevant when it clearly played a part of the factual basis of the plea, as stated by the assistant district attorney? It was clearly part of the factual basis upon which this plea was entered. So it had to have some relevance or some weight to the entry of this plea.
Well, I would contend it does not. Looking at 14-202.1 and the criteria for that, and that's indecent liberties with a child, any improper, immoral act. We're not talking about attempted rape. We're not talking about attempted sex offense here. And I think that's what the defendant's kind of getting at, that, hey, these touches on the thigh are innocent parental conduct, which it is not. This victim was 15 years old. She had a mother that resided in the household with her. And I think societal norms, and in fact, if you look at the statutory language or the editor's notes or the history under 14-202.1, I guess it talks about common sense, I guess societal beliefs or common sense, what is considered appropriate or inappropriate. And it can be with either sex. However, in this context, we're talking about a 15-year-old girl by her age and the fact that she wore a bra. We can infer that she was in pubertal stage. She was well developed. She was a well-developed female. And we have her father not only once, but twice touching her, second time, according to him, accidentally in a dark room on her thigh, which the defendant contends, oh, that's innocent parental conduct, which maybe with the first one, but the defendant wants this court and the trial court to believe that twice in May, then June, this behavior occurred just incidentally. It was like innocent behavior. It was by accident. So I think we have to look at that type of behavior. We have to look at the age of this victim. And we have to look at the fact that she is in a pubertal stage and what societal norms dictate for the interactions between parents and children. So I think when you have a child, the child is an infant, is a young child. And I think parents sometimes may dress themselves or unrobe themselves in front of their child. However, I think societal norms, they dictate that stops. And certain touching behavior from parents of the opposite sex also stops. Now, I think of course, we have a different scenario now when we're dealing with sexual orientation issues. However, we don't have that issue here. And societal norms dictate a certain standard of behavior when parents of the opposite sex are dealing with their children, such as when a child gets to a certain age, a female child or a male child, I think the parent of the opposite sex may stop bathing that child. So I would disagree that this is innocent parental conduct. And even giving the defendant the benefit of the doubt, some arguendo that the May incident was innocent parental conduct, but we have the same exact behavior again. And then, of course, it escalates even more in July. And that is the one that we're talking about, the one that she recanted. It's the one that, of course, the defendant alleges is the more egregious. However, that does not take away from the fact that the prior two do not qualify for indecent liberties under 14-202.1. Because as it applies to indecent liberties, there's no requirement as to the digital penetration or attempted digital penetration or the attempted rape, penetration of the labia or anything of that nature. So that's not what we're talking about here. Indecent liberties, and the court can take judicial notice of that and societal norms and touching of certain places on people as being inappropriate, immoral, and improper. And in here, the defendant has failed to establish prejudice. And the state we have, I guess, listed out, talking about the July 2011 incidents. As I previously stated, the other two incidents, the May and the June incidents, there was more than sufficient evidence for those, and the jury could have inferred. The jury could infer from the circumstances of those two events that he had that sexual purpose. So it wasn't a requirement to pull her pants down. It's not a requirement to do that. Indecent liberties doesn't require that. And I would encourage the court to look at that statute, which is cited in the briefs, and the case notes that follow. So that's not a requirement because we're not talking about any more egregious behaviors such as rape or sex offense or an attempted rape or attempted sex offense here in this particular case. So under the facts and the circumstances of this case, there is not a reasonable probability that the defendant would not have pled guilty and insisted on going to trial. There are no further questions. The state will rest on its brief.
Judge Hampson, Judge Jackson, do either of you have any further questions for Ms. Lawrence?
No, Judge.
Yeah, I have nothing further. Thank you.
Okay, thank you.
Thank you, Your Honors.
Ms. Muma, you may proceed with your rebuttal.
Thank you, Your Honors. I think it's important to go to the language within the plea hearing with regard to the recantation. And what the prosecutor says is, Casey was unhappy when she left the state, recanted the allegation, saying it wasn't true because she wanted to come back to where she lived. Had the defense attorney actually looked at the forensic interview, had he had any real knowledge of what was in that forensic interview, he would have heard Casey saying it never happened. Not, I wanted to come back home, not, I wanted to be with my friends, but it never happened. He looked at my back to look at the rash. He never looked at my front. He never touched me. She completely recanted the allegations. She did not say it was because she was homesick. The state has referred to alleged errors by defense counsel, that the trial court noted alleged errors. The trial court noted what the defense counsel himself testified to. So these were not alleged errors. These were acts that the defense attorney said were the limited acts he took in this case. He also, although he wavered on whether he showed the defendant the video, which if he had seen the video, he would have should have objected to the way that recantation was explained by the prosecutor. But that is totally contradictory to his saying that he conducts no investigation and he does no interviews unless he knows there's not going to be a plea. The state refers to how the jury could have inferred this non-innocent sexual arousal incentive for touching his child's thigh, but doesn't recognize that there was witnesses to these events. There was the sister who was in the room, and if the defense attorney had interviewed the sister, the tick incident would have been confirmed. There were 3 teenagers in the other room, and had those teenagers been interviewed, they would have confirmed that yes, that they unscrewed the light bulbs, and the father was actually doing his parental duty by going into that room, finding out what was happening with 4 teenagers in a dark room, and that there was no sexual intent whatsoever. The state talks about how the defense attorney said he told the defendant. The question of when, I believe he did not tell him, but the question of when is certainly important. He admits that he only met with the defendant 1 time prior to the hearing. So the defendant, at best case scenario, found out at the time he was going into a plea hearing that he wasn't aware of when he arrived at the courthouse. The first time he heard about the plea was when he got to the courthouse. And at that time, he was told that his wife was at risk of losing custody of the children. Not only was he at risk of not being able to see his children or reside with his children, but his wife, the mother of the children, was at risk as well. This was a case where a family was unnecessarily broken up. If you read the transcript from the hearing, you'll find that when the defense attorney answers questions with some confidence about what he did and did not do, he then later says, I really can't be sure. I really don't remember. I don't have my files, even though the case was not that old and he clearly destroyed the files or lost the files before the time when files should be destroyed. But then even when post-conviction counsel offered to try and help find those files, he refused that assistance. The state, I did mention pro se, ineffective assistance of counsel, and I understand that is not defined by the law as per se, ineffective assistance of counsel. What I said was, it ought to be, it ought to be that if a defense attorney says, I don't conduct investigations, I don't conduct interviews, I'm basically there to make sure a plea goes through, that does not meet the ABA guidelines, does not meet the professional rules of conduct, does not meet the requirement that we have confidence in the outcomes of our justice system, and that people have counsel that they can rely on to give them direction in the courts. So I recognize it is not per se. There was a lot of discussion during the state's argument about what should be appropriate in society and which should not, with regard to children and bathing, and all of that is completely irrelevant to this case. All that is relevant to this case is this man was pled to 2 indecent liberty charges because his counsel did not tell him that the 3rd allegation, which actually had accusations of sexual arousal by fondling of the breasts, was completely recanted. That is the gist of the problem. And this case came forward originally because the child came forward and said the tick incident was the tick incident. And the incident in the dark was an incident in the dark. So she actually came forward saying those 2 other incidents didn't even happen. That's how this case got into post-conviction. The position of post-conviction and how we were able to get discovery and it became clear the extent of the ineffective assistance of counsel. So in summary, we believe the prejudice prong, there was clear prejudice by the lack of investigation. If counsel had investigated, there is no question this defendant would have insisted on going to trial. That the judge's conclusion that the 3rd incident was unrelated to the other 2 was the wrong conclusion, and that the judge's conclusion that with additional investigation would not have resulted in evidence that would have changed the defendant's decision to plead guilty, it was a false conclusion as well. We asked the court to, at a minimum, remand for findings of fact, but also believe that the court has sufficient evidence within the record to establish findings of fact that were undisputed, that would justify dismissal on the basis of ineffective assistance of counsel and lack of evidence to support the elements of indecent liberties. Thank you, Your Honors.
Sorry, I was muted. Judge Hampson, Judge Jackson, do either of you have any further questions?
I don't think.
I do not.
Okay, thank you, Ms. Muma. That concludes oral argument in this matter. Thank you, counsel, for your excellent arguments and your participation in WebEx oral arguments today.
Thank you, Your Honors.
This session of the North Carolina Court of Appeals is adjourned.
Have a good day. Good seeing you all.
Yeah,
You too. Thank you.
Thank you. Bye-bye.